Most of us know the statistics. 1 out of every 2 marriages ends in divorce. For those who remarry, there are many complicated questions to address. How do I provide for my new spouse and still protect my assets for my children? How do I protect my assets from another possible divorce? How do I plan for the disposition of my estate in a blended family situation? For Robert and Terry, who were each on their 3rd marriage, these questions weighed heavily on their minds.
Being my 3rd marriage, I was concerned about being taken care of, and Robert had all the assets. So because of that, I wanted to make sure that situation that he was taken care of, that I was taken care of, and that his kids were taken care of.
And I wanted the same. I wanted to make sure that Terry was taken care of. I love her deeply, and I'm also wanted to assure a smooth transition after Terry's passing to my children. And that was the concern. I wanted that documented legally and in a manner that everyone could understand and implement.
To make matters more complicated, Robert also wants to remain the sole trustee on the house he has owned for more than a decade, while allowing Terry to live in the house rent-free should he die first. And since the house also generates income through rental revenue, Terry can use this income throughout the rest of her life.
As a result of the divorce mediation, I became the sole owner of the house here. The situation is that I, along with Terry, wanted to develop a community of friends here to live in the house. There are 7 of us here now, and I wanted to make sure that Terry would be able to remain in the house after my death, to be with our community of friends, and to derive the income from the house. I also wanted to assure that the house would, upon Terry's death, pass through to my children.
Because California, where the couple resides, is a community property state, most people don't know that with a joint trust like Robert and Terry will have, assets can be owned 3 different ways. Jim Krupka, the estate planning attorney who counseled Robert and Terry, explains.
The way that I draft my revocable trust for married couples, there are 3 different ways in which they can take title to property. If we have Robert and Terry as co-trustees, then it's community property. But if we have Robert, for example, as the sole trustee, then it's Robert's separate property. And if we have Terry as the sole trustee, then it's her separate property. So, depending on how they want to take title to their assets, it's possible for them to have up to 3 different schedules for their trust. Community property, both husband and wife, just the husband, his separate, just the wife, her separate.
But even more questions come into play. What if Terry fails to make the mortgage payments or pay property taxes? What if she doesn't properly maintain the property? What rights will Robert's children have? That's where naming a co-trustee with Terry comes in, says Krupka.
In this trust business, oftentimes it's a lot like the Wild West. Trustees can run amok and cause problems among beneficiaries. Not that this would happen necessarily in Robert and Terry's situation, but by having Terry as a co-trustee with Robert's daughter, Megan, it really was perfect, because this way, if Terry, who's responsible for mortgage payments, property taxes, insurance, maintenance, repairs, etc., if she messes up, as the co-trustee, Robert's daughter, Megan, is going to be the first one to know about it. And this way, Robert's family is in the loop. Terry is on board with this. She's very comfortable working with Megan, and it's a win-win situation for all parties.
Not all estate planning situations are as complex as Robert and Terry's, but almost all have factors that can make the average person confused and overwhelmed. That's why experts like Krupka say when it comes time to plan for your estate, especially when dealing with blended family situations, it's vital to seek legal advice and counseling and not try to figure it out yourself.
Robert and Terry recognized the fact that their situation was enormously complex, and that's why they came to me. Many people, most people that have those types of situations get stuck and don't seek legal advice, try to work these solutions out themselves, and they can't. And by the time they get into an attorney's office, which is oftentimes years or even decades later, there's such an explosion of emotions that occurs that it gets very, very difficult to put the pieces back together again for these people.
Well, absolutely, we needed help. I had downloaded a will and trust form from the internet. I'd started to fill it out, and I was feeling very uncomfortable about that, and sought legal assistance. And Jim was great. Jim not only explained all the legalities of it, the options we had, made recommendations. We went through different scenarios and arrived at results that were alleviated all our concerns.
For 20 years, Jim Krupka has been providing personalized professional estate planning solutions throughout the Santa Rosa area. With offices throughout the San Francisco Bay Area, San Rafael and Napa in the North Bay, Pleasanton and Walnut Creek in the East Bay, downtown San Francisco, and in Silicon Valley with locations in San Bruno, Foster City, and Mountain View. Jim's unique approach includes getting to know a client's family dynamics, learning about a client's personality, and developing a plan that reflects each unique situation. Backed by a team of skilled professionals, Jim can help resolve even the most difficult and complex estate matters, including estate planning, probate, wills, trusts, and more. Whether it's a situation like Robert and Terry or just helping a client provide for their heirs, Jim loves what he does, and it shows in the trust he's earned in his clients.
I would say about 95% of my clients that come to see me have never been to an attorney's office before. And if they're lucky, that'll continue to be the case. One thing that I think sets me apart from the stereotype is that I speak in plain English. I enjoy working with people, and also work on a flat fee basis, and we do full service here, which means that when you come in to get a revocable trust done, we do all the asset transfers. You come in, you sign the documents, you leave the office, and you're done.
He really tunes into the emotional aspects of the situations that people bring. Sometimes they can be very complex. You have blended families, adoptions, different feelings between family members, differences of opinion about what should happen with the assets that are being passed on. And that can be very complicated. And Jimmy's also very good at helping with that complexity, helping people break it down, dissecting the situations, and helping people come to conclusions and decisions that will make them happy, so that when they leave with decisions that they're comfortable with and they feel confident about.
Well, he was just so knowledgeable about the legalities as well as his personalities. He was very inclusive. Terry had concerns about being included. He was wonderful about that. We looked into many of Terry's concerns in the course of our interview. She was treated with the utmost respect, and I, of course, appreciated that greatly. And it was a wonderful experience.
This was such an enlightened kind of experience. And I use that word that I learned so much, that we learned so much, and that it's even information that Jim gave us that I've been able to tell some of my friends about, so that as they're setting up for their divorces and getting ready to do their will and trusts, that they're able to benefit from what we benefited from Jim. I think that he is just a remarkable man in the way that he treated us and took care of each of us and our needs with such professionalism and really a great deal of knowledge, and passed it on in a way that we each understood it and that I understood it, and I could make decisions out of that, which was wills and trusts, not an easy thing, you know, it's very complicated. But he really unraveled it in a way that we could understand it and make powerful, insightful decisions.
To find out more about the law offices of Jim Krupka or to schedule a consultation, please call 707-542-4349 or visit jimkrupkalaw.com.